In a scathing observation regarding the alleged state of executive actions in Uttar Pradesh, the Allahabad High Court recently observed that punitive demolitions of structures continue to take place in the state despite the Supreme Court's November 2024 decision in bulldozer justice. The court further questioned the state government as to whether demolishing a structure immediately following the commission of an offence is a colourable exercise of executive discretion. A division bench of Justice Atul Sridharan and Justice Siddharthanandan observed that it has come across various such cases in which the notice for demolition was issued to the occupants immediately following the commission of an offence. Thereafter, the dwelling places were demolished after the ostensible fulfillment of statutory requirements, the bench noted. Therefore, bearing in mind the overarching nature of the case spanning the right of the state to demolish a structure and the rights of its occupants under Articles 14 and 21, the court framed the following 5 questions of law for the parties. 1. Is there non-compliance of the judgment of the Supreme Court's November 2024 judgment with specific reference to paragraphs 85 and 86 of that judgment? 2. Does the authority to demolish justify the act of demolishing a structure, or is there a duty on the anvil of parens patriae upon the state, not to demolish a dwelling place in the absence of public need/purpose? 3. Are steps taken to demolish a structure immediately following the commission of an offence a colourable exercise of executive discretion? 4. How can High Court balance the conflicting interests between the statutory authority of the state to demolish a structure and the fundamental right of the average citizen under Article 21 and 14, to prevent it? And 5. Can reasonable apprehension of demolition be a cause of action for a citizen to approach this court, and if yes, what is the bare minimum for this court to hold the existence of such reasonable apprehension? The matter will now be heard on February 9. For context, the bench was hearing a writ petition filed by Faeemuddin and others who claimed that their relative, Afan Khan, was named in an FIR under various sections of the BNS, POSO Act, IT Act and the UP Prohibition of Unlawful Religious Conversion Act. The petitioners alleged that, though they were not co-accused in the said FIR, they were targeted by a mob allegedly in collusion with the police. Before the bench, they raised a reasonable apprehension that their properties, situated in Hamirpur, including a residential house, a commercial lodge and a sawmill, were marked for destruction by mechanical means by the authorities. They claimed that the commercial lodge and sawmill have already been sealed by the respondent authorities. Therefore, they sought the intervention of the High Court to prevent the anticipated destruction of the properties. The state government, however, raised a preliminary objection that the petition is premature and that the petitioners must respond to the notices issued to them. In fact, an oral assurance was also given to the HC that no demolition would take place without adhering to the procedure established by law and without affording the petitioners a due opportunity to place their case before the authorities concerned. However, noting that such demolitions have continued in the state despite the Supreme Court's order, the bench deemed it appropriate to address the questions it has framed in the order passed on January 21. Senior Advocate S.F.A. Naqvi, assisted by Advocates Shamsuddin Khan, Syed Ahmad Faizan, and Zahir Isga, appeared for the petitioners.
Subscribe for more. Thanks for watching.